Welcome to the long-awaited final round of the February 2025 International Mock Trial Championship. 44 teams started, only 2 remain, and our esteemed panel of judges is going to help us determine who is the ultimate winner. We're going to go through them step by step. They'll introduce themselves. We're going to start with Judge Cole Alfonso.
Hi everyone, it's an absolute pleasure to be here. My name is Cole Alfonso. I just graduated from UCLA with a double major in political science communication, hoping to end up on going to law school someday. My mock trial experience is my fourth year doing competitive mock trial for UCLA. These last 2 years, I've captained our varsity teams. 2 years ago, we were fifth in the nation. The previous NAS experience, we ended up at third. And then this year with co-captaining with obviously another judge, Hannah Lay, and we'll be making our Nats run momentarily. So I'm super excited to see what y'all have put on. I'm really looking forward to a great show. I'm really looking forward to witnesses, attorneys. So just really excited to be here and absolute best of luck to both teams.
Judge Hannah Lay.
Hi, everyone. I am a third year at UCLA. I'm a math major and I compete on the mock trial team here as well. Like Cole said, I'm currently his co-captain this year. We're both captaining our A team. And he was my captain last year when we got fifth place at nationals as well. So that's mock. And on the judging side, I've judged for PPMT, but the summer version for 2 years in a row now. And I coached my own team, UWC. So we've got some pretty good placements at Empire, at TOC, top 5, things like that. And I just want to say to both teams, no matter what the result of this round is, a congratulations to both of you because you guys have done so well already. And I hope you guys are proud of yourselves.
Judge Janito Simon.
Hello, guys. Congrats to both teams. I am a 12-year practicing attorney. I do criminal defense. Last, I guess, 2 years, I've been doing almost exclusively homicide or very serious, those type of cases. Mock trial wise, I am a coach for Florida High School. I happen to have coached the 2024 Gladiator, Mr. Marvin Exantis. I've coached FSU Law School to their Chester Bedell Big Florida Law School competition. I help out with the FSU undergraduate team, and I've been doing mock trial or mock trial related, either coaching or competing since high school. I look forward to both teams. I'm looking for whoever can win the moment, whether or not as a witness, as a lawyer, just find a way to just win that moment, whether or not it be with drama or humor. I think that's what championship rounds are made for. So look forward to seeing both teams.
Our championship trial presiding judge, Mr. Brandon Benjamin.
Hi guys, how's it going? My name is Brandon Benjamin. I am currently a middle school history teacher and a varsity basketball coach. I graduated from UCLA in 2020 with degrees in political science. I then got my master's in education. While I was at UCLA, I competed in mock trial for 3 years, and I've been coaching there for the last 7 years. I was a coach on the 2023 national championship team. I have coached trial by combat at the college level, trial by combat competitors. I have coached and started the Gauntlet, which is a specific witness-centered tournament at the college level. And so super excited to be here. Super excited to see this is my first time judging at IMT. And really just looking for those who can adapt. Things are going to go wrong. You guys have trained for this. You guys are ready for it. Super excited for this round.
Now, competitors, you might be thinking at the championship round, I just was introduced to 4 judges. Are we going to break the tie? Well, in recognition of the fact that this team met each other in the last tournament semifinal and had the closest out round in IMT history, here's what's going to happen. If this round, according to these 4 judges, is a 2 wins and a tie in favor of one of the teams, congratulations, that team wins. If it's 3 wins and 1 loss, that team wins. If it's a sweep, of course, that team wins. But if it is a 2-2 tie amongst these judges, the recording of this championship round will go to my coaches. the people who coached the 2011 and 2014 championship teams for college, and they will be the arbiters of who takes home this title. So we'll see if it's decided about 2.5 hours from now or at a later time. But regardless, let's put on a fantastic show for both your current judges and prospective future judges. With that, I'm going to turn my camera off. All cameras go off with the exception of our presiding judge. And let's take it away.
All right. Just to make sure that I'm getting this right for my presider script here. My name is Judge Benjamin. Let's go ahead and call the case of State v. Tanks. Scoring judges, please do me a favor. Look at the bottom 2 buttons on the lower left of your screen. Remember to keep your audio off and your video off until the end of the trial. You should also have your video set to hide all non-video participants. Judges, please remember to be leaving comments throughout the trial and scoring as you go, clicking save often so we don't lose any of that progress. Whoever is timing for this trial, please identify yourselves. You guys can
be timing for the defense in today's trial.
Perfect.
I'll be timing the opening for the defense, but Ethan should be timing everything else.
Okay.
Thank you.
Thank you. Do we have a timer for the prosecution?
Unfortunately, we
Yes,
don't have
Your
it
Honor.
yet. We'll be like hopping around.
That sounds great. So just remember, we will be following our time constraints here. 18 minutes to direct examinations, 16 to share between cross, 6 minutes for closing arguments. Time stops during objections. All right. I'm off script now, but we are on the we are at least on the case here. Let's go ahead. Are both sides present and ready to proceed?
Yes, Your Honor. Prosecution is present and ready to proceed.
Defense is ready to go, Your Honor.
All right. Prosecution, what you got?
First, can we make introductions?
Let's do it.
Yes, Your Honor. Good morning, Your Honor. My name is Anya, and today joined with my co-counsel, Mr. Jiachen.
Good morning, Your Honor.
Together, we represent the state of Chile in today's case. After the defense has made their introductions, we have a few housekeeping matters we'd like to address.
Okay. Defense?
Yes, Your Honor. Hello, Your Honor. My name is Christiana Garcia, and today I'm joined by my friend, Audrey.
Good morning, Your Honor.
And Miss Ma just so happens to be my colleague today, as we represent Miss Jimmie Tanks.
Good morning.
Okay. Prosecution, you mentioned some pretrial matters?
Yes, Your Honor. First, we'd like to invoke Rule 603 and 615, which constructively swear in and sequester all witnesses, barring party representatives.
Okay, so invoked.
Next, would Your Honor prefer for us to ask permission each time we share screen, or simply state for the record that we'll be doing so?
I'm going to go ahead and have you guys just state for the record. No need to ask permission.
Yes, Your Honor. And finally, in the event an objection is sustained, would you like for us to strike it from the record, or simply assume all offending testimony is already stricken?
Go ahead and strike, or move to strike for it.
Yes, Your Honor. And with that, the prosecution is ready to proceed.
All right. Defense, you guys got anything before we go?
Yes, Your Honor. 2 things. First, we would like to designate Miss Jimmie Tanks as our party representative.
Okay.
And second, we would like to bring the court's attention to case law currently being displayed on screen. Miss Ma, can we please get case law up?
Yeah, give me 1 second.
At this time, Your Honor, we would ask for the court's indulgence.
Of course. I also have access to the case law as well. If you just want to point me to the name, I can get a quick preview of it before you guys get it up there.
Your Honor, we could. Yes, Your Honor. Currently, we're having some technical difficulties. Our tech is having a hard time displaying anything on screen. Just to confirm, can we make sure that we have permission to screen share?
I'm going to have Dr. Lampert check that out. I think you do. I think you're good.
Looking like it too, Your Honor. Your Honor, as we can see on screen, we're going to bring the court's attention to State v. White 1904. In a criminal case, the burden of proof is beyond a reasonable doubt with respect to every element of the charged offenses, and the burden is on the state and never shifts to the defendant.
Okay. Any commentary on that, prosecution?
No, Your Honor.
Okay. Thank you.
With that, we're ready to get this show on the road.
All right, let's do it. We'll go ahead and have everyone turn their cameras off except for our prosecution opener here. And you can start whenever you're ready.
Yes, Your Honor. Her theory fueled the fire. It's July 1st, at midnight, and the defendant, Jimmie Tanks, isn't soundly asleep in bed. Instead, she's parked in front of a 2-story home with containers of gasoline in her back trunk. The house she's parked in front of doesn't belong to her. Instead, it's the property of Bertie Darrow, an arch nemesis who cost the defendant everything. Or her university scholarship, or her future, and her freedom. As the defendant sits in that car, the only thing on her mind is revenge. So she finally gets even when she sneaks onto that property, spreads gasoline all around the home, and sets it all on fire. Bertie Darrow barely escapes the flames with his life, and will be left with a long burn scar on his arm for the rest of it. Members of the jury, the defendant's fury fueled the fire. And as the prosecution, we understand that we have a burden today to prove to you beyond every reasonable doubt that this defendant committed both first-degree arson and attempted first-degree murder. To do this, we'll show how the defendant intentionally set Bertie Darrow's house on fire with intention to kill, but instead left him with that burn scar. Members of the jury, we'll meet this burden today. Walk you through every piece of evidence step by step with 3 simple facts: fury, fuel, and fire. Starting with the fury. Members of the jury, you'll learn throughout this entire trial that the defendant wanted revenge. On February 26th, her high school bully turned her in for theft, as she lost her scholarship to a prestigious university, a successful future, and spent 3 years behind bars. All because of one person, Bertie Darrow. The defendant promised Bertie Darrow would pay with his life, and her fury fueled the fire. So second, the fuel. You'll learn today, members of the jury, since the defendant was sent behind bars, she wasn't wasting time. A security guard from the jail she was imprisoned in will tell you under oath today about a drawing the defendant drew of a burning house. On that drawing in the upper left corner, you're going to see a few familiar dates: February 26th and July 1st. February 26th, the day Bertie Darrow turned the defendant in for theft and ruined her life. And July 1st, the night of the fire. She's been plotting revenge for years, and her fury fueled the fire. So finally, let's talk about that fire. Members of the jury, today, a fire investigator will take the stand and walk you through her investigation. How she discovered someone had poured gasoline all around Bertie Darrow's home and intentionally set it on fire. But within the next hour, when she went to arrest the defendant, she found her frantically trying to dispose of that same gasoline into containers and never to be seen again. But members of the jury, we uncovered what the defendant was trying to bury, and when the facts start to add up like that, it tells us a story. Her fury fueled the fire. And that's why at the end of today's trial, my co-counsel, Mr. Jiachen, will come before you and ask you to reach the only fair verdict. Find her guilty. Thank you.
Thank you, prosecution. Defense, you may proceed when you're ready.
Yes, Your Honor. She forged a fire for funds. $225,000. That's the number staring Bertie Darrow in the face. She's looking at her debt she can't pay. She's a high school gym coach, not a millionaire. She's desperate. And it's only getting worse. She's trying to gamble her way out of it. Failed. Try to get more loans. And failed. And now, you're going to learn she was going to lose her home. Today you'll learn this fire was fueled with Miss Darrow's desperation because it turned to deceit the day she took a pen in one hand, signed an insurance policy. Today you'll see this policy wouldn't just protect but pay Miss Darrow almost $1 million if her home was on fire. Folks, you'll learn that on July 1st, 2024, Bertie Darrow forged a fire at her home to deceive the insurance company and get a payout. She forged a fire for funds. So, what does Miss Tanks have to do with this? You're going to learn the 23-year-old woman on screen is on trial today because Bertie Darrow forged a fire and then try to use Miss Tanks as her scapegoat. And Miss Darrow's forged truth has fueled the state's case. Like Miss Lau just told us, they've charged her with 2 things: first-degree arson and attempted first-degree murder. They gotta prove those claims to you beyond a reasonable doubt. Meaning, if there's a reasonable possibility that Miss Darrow, not Miss Tanks, forged that fire, then Miss Tanks isn't guilty. And while we're not obligated to, we're going to show you this case boils down to 2 things: a woman who needed funds and the fire she forged. Because the state just told you about fury fueling the fire, but you'll learn this fire occurred because Miss Darrow had a need for funds. Her need for funds fueled this fire, and that's why the first fact will tell you that she needed funds. An insurance investigator will show you Miss Darrow was in fact $225,000 in debt. You'll see up close and personal that Miss Darrow's insurance policy, well, it would pay her almost $900,000 if her home went up in flames. So second, the fire she forged. Miss Lau just told you about the fuel, but you'll actually learn the real cause of this fire was paint thinner. Today you'll hear from a hardware store worker who will show you a receipt of Miss Darrow buying large amounts of highly flammable paint thinner just weeks before the fire because she forged a feud. Rather, she forged a fire for funds. And today, Miss Tanks sits on trial innocent unless proven guilty. Miss Tanks, well, she was somebody who was used as a get-out-of-jail-free card. And that someone was Miss Darrow. So today, at the end of the trial, when you see all the cards on the table, it will be clear this fire wasn't caused by fury. It was started because someone needed funds. So that's why we'll ask you to find Miss Tanks not guilty. Because Bertie Darrow forged a fire for funds. I appreciate your time, folks.
All right. Thank you, both sides. Before we proceed into the state's case here, please make sure that you guys are in gallery view moving forward so we can see both the witnesses and the attorneys while they present. With opening statements having concluded, State, do you guys wish to put on a case?
Yes, Your Honor. We are now calling Dr. Huntley Blaze to the stand.
All right.
Your Honor, may I proceed?
You may.
Now, good morning, Doctor. Can you please introduce yourself to the court?
Good morning, sir. My name's Harley Blaze. Yes, that is my real name, and yes, I do get that question a lot.
And what do you do for a living, Miss Blaze?
I'm the lead fire marshal at the Tilly Fire Department. Basically, I find out why things go wrong when they do.
How did you become a fire marshal?
Well, as a kid, I was the type to roast marshmallows way too close to the fire and accidentally set my eyebrows on fire. Twice, actually. So I figured if I like fire so much, I might as well make a living off of it.
Can you tell us your qualifications for your work?
Of course, I earned my associate's degree in fire science, a bachelor's in engineering, and a doctoral degree in chemistry. All three certificates from the National Association of Fire Investigators. You could see in the back there.
And what hands-on experience do you have working with fire investigation?
Well, I've had specialized training and also got myself plenty of hands-on experience as the Tilly Fire Department's lead fire investigator, and later on lead fire marshal after I got promoted. I've been on the ground for so many cases. If there's smoke, I've probably been in the middle of it.
And Doctor, have you testified in court before?
Yes, sir. I've testified several times before out of the hundreds of cases I have investigated.
I want to talk about why you're here with us today. Do you know the reason why you're in court?
Yes, sir. I'm here to talk about my investigation of the origin of the fire that happened at Bertie Darrow's house on July 1st of 2024.
And what steps did you take by investigating the fire?
As soon as I got notified by our fire department at around midnight, I went straight to the scene of the fire to collect evidence. I then tested that evidence to find a matching origin of fire.
Can you tell us what method you used to test the evidence?
Yes, I used the standard forensics protocol for investigation based on evidence collected from the night of the fire. I also reviewed 5 other witness statements and went over several of the exhibits.
Did you apply that protocol reliably?
Yes, sir, of course.
Your Honor, pursuant to the pretrial order, Dr. Blaze is already entered as an expert in fire investigations.
Any commentary on that, defense?
No, Your Honor, that's our understanding as well.
All right, thank you.
Doctor, I want you to help the jury set the scene. So you arrive at the house. What do you see?
By the time I got there, the fire itself was mostly all under control. I saw Bertie Darrow, pretty badly injured, but still up and speaking with some officers.
Badly injured? Ma'am, what do you mean by that?
Well, Darrow had this horrible burn running up his entire right arm. But other than that, he seemed to be doing all right. As for the house, though, that's an entirely different story.
And what about the house made it an entirely different story?
Well, let me show you. So I made this generic model of a house. And I'll ask you to just look at the first floor of the house here, around the perimeter. That's where the house suffered the most damage, as it's highlighted red here.
Were there any other burn patterns on the property?
Yes, sir. When I went around the house to the backyard, I found it was especially filled with very noticeable burn patterns over in this red area, all found on the ground in the backyard.
And what do all these burn patterns mean for a case?
Well, in our case, burn pattern had a specific puddle shape to them.
Can you tell us what a puddle shape means?
Of course, a puddle-shaped burn pattern typically indicates that there was a flammable liquid present at the fire, and possibly intentionally put there.
Doctor, is it difficult to confirm the origin of a fire when you have a puddle-shaped burn pattern?
Well, sometimes, especially in a place like an enclosed room, there may be things like carpets that cover the floor from a fire, which might create a sort of a fake puddle shape, but I can say that's not the case here.
Why not?
Well, the puddle shapes at Darrow's house were all found outdoor, in the backyard, outside the kitchen window, and along the brick walls. There was nothing around that could have caused one of those fake puddle shapes. No carpets, no furniture, nothing like that.
I want to help the jury understand what fueled the fire. Now, did you analyze the fire debris at the house?
Yes, sir. I collected 4 different samples from 3 different areas of Darrow's house that looked to me like pour patterns, and I evaluated the samples in my laboratory.
Can you tell us how you evaluated the fire debris?
Of course, I used gas chromatography mass spectrometry, or just GCMS testing for short. It has an accuracy of near 100%.
And for the sake of the jury, can you tell us what GCMS testing does?
Of course. So, to put it simply, GCMS tells us what compounds are in an unknown sample and how much of each compound there are. And I have a visual aid to help demonstrate what this test essentially does.
All right, go ahead, Doctor.
All right, so I'll show the setup first. I'll use a marker to draw a line on the chromatography paper. That marker's ink would be the sample. And then I'll place the sample in this container, which is filled with a little bit of water, and I'll lower to the marker line.
Now, how do you recognize if the material is the same as the one you were testing?
Well, for now, we just let the marker's ink move up the paper on its own. And here I have an example of a finished chromatography.
Now, Doctor, did you apply your method reliably here?
Yes, sir, I did.
Now, would you recognize a copy of your actual results if we were to show it to you in court?
Yes, sir, I would.
Your Honor, stating for the record, my co-counsel will not be screen sharing a copy of the results. Doctor, are we looking at a true and accurate copy of your testing right here?
Yes, sir, looks like it.
Now, Your Honor, we are now entering Exhibit 7 into evidence.
Any objections?
No objections, Your Honor.
Okay, 7's in.
Doctor, walk us through, what does this document depict?
Well, as you can see here, the chromatographs here of the ignitable liquid samples line up exactly with the gasoline. And this means that the 2 liquids were made of the same compounds at the same ratio.
Doctor, bringing your attention to the defendant, did you ever interact with her?
Why, yes, sir. I was the one who arrested Tanks after I drove to her house and saw her in the backyard getting rid of some liquid. She was pouring it into a waste bin.
Objection. As to lack of foundation, may I be heard?
You may.
Your Honor, up to this point, we haven't heard any foundation as to what led Dr. Harley Blaze to investigate the defendant. We feel as if this is important foundation for the members of the jury to make sure they understand the whole situation of this investigator's investigation. Your Honor, we would ask that that foundation is laid.
Response?
It is stipulated that Dr. Blaze had the probable cause and followed the proper procedure by arresting the defendant. Now, if defense would like to challenge the credibility of a part of her investigation, they can feel free to do so on cross-examination, but right now that foundation is not necessary based on the court records.
Your Honor, may I be heard?
Yeah, last word.
Your Honor, I'm not specifically objecting to the investigation. We understand that is stipulated. That's not an issue. Rather, we're objecting lack of foundation as to why this specific investigator started to investigate Miss Jimmie Tanks. Whether that was by somebody telling her that it was Jimmie Tanks or whether she had a lead from some other source, we haven't heard any foundation up to this point. And we would ask that that foundation is laid because the members of the jury needed to fully evaluate this situation.
I think you can probe into that on cross-examination. So at this point, I don't think it's needed. I'm going to overrule that objection.
Yes, Your Honor.
Dr. Blaze, just to remind the jury, did you ever interact with the defendant?
Yes, sir. I was the one who arrested Tanks after I drove to her house and saw her in the backyard pouring some liquid into a waste bin.
Do we know what liquid the defendant was trying to get rid of?
Yes, sir. It was confirmed that the liquid was gasoline, the same material that burned down the house.
Doctor, looking at all the evidence we have before us, what is your conclusion about the events of July 1st when the house burned down?
Considering the tests performed plus the puddle shapes I saw at Darrow's residency, it all indicates to me that somebody intentionally set fire outside Darrow's house using gasoline.
Thank you, Doctor, for your testimony today, and Your Honor, no further questions at this point.
Cross?
Yes, Your Honor. Hello, Dr. Blaze.
Good morning, ma'am.
Let's see if your investigation covered all the bases. Ma'am, a moment ago you showed us a visual aid for that GCMS test, right?
That's right.
Let's show the members of the jury another visual aid. Say I take this water bottle. I only look at the surface area, top, bottom, but I never unscrew the lid. It's reasonable to say I couldn't know what liquid is inside.
Yes, that makes sense.
And it also makes sense that I couldn't know whether there was water or soda because I never unscrewed the lid, right?
That's right.
And ma'am, you said a moment ago, if there's a fire, you've probably been in the middle of it. It's true that in this case, well, you weren't in the middle of Miss Darrow's house gathering samples from the interior of the building, right?
That's right.
All right, and going back to that water bottle analogy, like you agreed upon, if you don't open up the lid, you can't know what liquid is inside. Well, you never went inside Miss Darrow's house and gathered samples, right?
No, ma'am, that's not true. I did go inside the house and I searched the entire house multiple times. There just weren't any burn patterns inside the house for me to collect samples from.
Exactly, so you couldn't collect burn samples, right?
That's right, not from the interior of the house.
And since you didn't gather samples from the interior, well, you weren't able to run tests on the evidence, were you?
That's right.
And doctor, you can't say, based off the test, you never ran if there was, for example, paint thinner on the interior walls, right?
That's right, though I can say that's highly unlikely. But that's a yes to your question.
That's a yes to my question. You don't know if there could have been paint thinner on the interior walls. Ma'am, I want to take a moment and see how solid the evidence pointing to Miss Tanks is. Ma'am, you told us a lot about fires and investigation. I want to investigate how you started to look at Miss Tanks as a suspect, all right?
Sure.
You started to suspect Miss Tanks as a suspect because Bertie Darrow pointed the finger at her, right?
That's right.
Bertie Darrow, the person whose house burned down. Well, she was the only person who told you that.
That's right. And I did interview a neighbor who also talked about a figure in the backyard.
And just to make it clear for the record, that figure, well, it was a black, shadowy figure that nobody could even tell the face of, right?
That's right.
And after Miss Darrow pointed the finger at Miss Tanks, you actually pointed your investigation to focus solely on her, right?
Yes, ma'am. I followed the lead, and all the evidence I had pointed towards Jimmie Tanks setting the fire. That's a yes to your question.
That's a yes to my question. So, ma'am, it's reasonable to say that if I turn my back, focus solely on this white wall, I might miss something you do.
Sure, that makes sense.
Let's see if you missed the real person who could have forged this fire because you were focusing on the wrong things. It's true Miss Darrow had almost $1 million insurance policy.
That's right. I was made aware of the insurance policy.
If her home ever went up in flames, well, she would get that money.
That's right. As long as the fire was outside of Bertie Darrow's responsibility and ability to know.
That's a yes to my question. She would get that money.
That's right, ma'am.
But despite that, despite the possibility of her getting almost $1 million, well, you didn't look into the possibility of Miss Darrow setting her own house on fire for funds.
That's right. It's neither within my expertise nor my responsibility to look at financial records. That's a yes.
And when I look back at your background, ma'am, I don't see any certificate saying you're a financial investigator. Do I have that right?
That's right. My sole responsibility is to investigate the direct cause of the fire.
So you can't tell these jurors that she had a gambling addiction?
No, I can't.
You can't tell me if she was in debt because she gambled?
No, ma'am. I can't tell you anything about Bertie Darrow's financial situation.
And despite having zero expertise in that field, well, you didn't make an effort to find someone who was to investigate the funds further, did you, ma'am?
That's right. Again, that's not within my responsibility.
That's a yes to my question.
That is a yes to your question.
Thank you, ma'am. I'll let you get back to your fires. At this time, Your Honor, no further questions.
Any redirect?
Yes, Your Honor. May I proceed? Doctor, I want to focus on what fueled the fire. Now, what was the fuel you concluded for this fire?
Well, based on all the tests and evidence I have, the gasoline was the cause of the fire.
And did the fire start outside of the house or inside the house?
Well, based on my investigation, it most likely started from the exteriors of the house, where there were pour patterns.
Thank you, Doctor, for your testimony, and Your Honor, nothing further at this point.
Any recross?
Yes, Your Honor. Dr. Blaze, I just want to clarify something you said a moment ago. You said a moment ago, it's most likely that the cause of this fire was gasoline. It's true, you can't be 100% sure, right?
That's right, though anything else would be highly unlikely and not very reasonable either. But that's a yes to your question.
That's a yes to my question. You can't be 100% sure. Your Honor, no further questions.
I am unfamiliar with the rules, just making sure. Is there any second level redirect that's allowed here?
Your Honor, I have no further redirects. May the
Okay.
witness be excused.
Yes, yes, you may. Thank you. State, you guys got anyone else?
Yes, Your Honor. We now call Billy Huxley to the stand.
Let's do it.
Good morning, Miss Huxley. Could you please introduce yourself to the members of the jury?
Yes, of course. Hello. My name is Billy Huxley, almost like Billie Jean. You know that one song that goes, she says, I am the one. I just wish Michael Jackson would write a song about me.
Well, ma'am, where are you from?
Well, grew up in Brisbane, Australia, smack dab in the middle of the city. Eventually, decided I had just about enough of the city and moved to a more peaceful town, Willow.
What do you do for a living?
Well, I would love to be a singer, but I'm just a prison guard. Actually, it's pretty funny. My whole family, they're guards of some sort. My pa's a bodyguard, my mom's a gardener, and my brother guards his PC like crazy.
How'd you get into this line of work?
Well, before I was a prison guard, I worked as a school guard. But that didn't work out. I wish I could say it was because of my side hustle as a singer, but, well, I did drugs.
Well, ma'am, do you still take those drugs?
No, I've been clean for 4 years. I passed all my drug tests and I never plan on touching those things ever again. My life, well, it's finally turned around since I got clean.
How'd you get clean in the first place?
Well, I was caught by Jimmie Tanks, smoking some weed while on the job at her high school. She turned me into the principal and eventually I was fired.
What happened after?
Well, I had to go through court, but in the end I got a new job. And now I'm a prison guard and thankfully not on the other side of those bars.
Did you meet Jimmie Tanks again after that incident?
Yeah, in jail. Jimmie was in for theft and told me that Bertie Darrow turned her in, and she said some things too. It sounded to me like they had some real bad blood.
Let's move on and talk a little bit further about the words of the defendant. What did she say that day?
Well, Tank said, I'll do whatever it takes to make sure Bertie Darrow suffers. I won't rest until Darrow loses everything Darrow loves.
Did the defendant say anything else?
Well, I wanted to talk about Taylor Swift's newest album, but Jimmie, she mentioned something about fire? Oh, Folklore is a fire album, all right. But she wasn't talking about that. She said, one day I'll show Darrow what true fire looks like.
Your Honor, stating for the record, the prosecution is now screen sharing a demonstrative. Co-counsel, if we can get this demonstrative up. Your Honor, since we're a little understaffed today, can time be paused while we sort this out?
Yeah, let's go ahead and pause time for this so we can.
Co-counsel, or if anyone else can get it up.
Your Honor, please excuse me. We are having some technical issues here.
No worries at all. You're totally fine.
Or rather, prosecution, if you guys would like, we could get that up for you.
Oh, it's actually demonstrative, so
I redact my statement.
thank you though.
If that could be stricken from the record.
Sure.
Well, we were on record? Okay. Co-counsel, are you having technical difficulties on your end, or can we have Dr. Blaze maybe screen share?
Well, I believe Dr. Blaze has left the courtroom, so it's just me right now.
All right.
No worries, I have it now.
All right. Perfect. Thank you for the court's indulgence. We can now resume time. The defendant promised to show what true fire looks like. Did she do anything in the days after?
Yep. She started talking to an arsonist.
Hang on a moment. Can you tell me more about that arsonist?
Sure. The guy's name is Alex Leonard, known around that prison for serving a really long sentence on malicious arson.
Did you catch anything they were saying?
Yeah, I remember, March 16th, and Leonard was telling Tanks to pour gasoline around the house at night. Objection on the grounds of hearsay?
Okay. Response?
Yes, Your Honor. We're not offering this statement for the truth of the matter asserted, or rather we're using it for the effect on the listener. It doesn't matter to us if what Leonard told Jimmie Tanks is true, that it really is best to pour gasoline around the house at night. Instead, Your Honor, if I may proffer.
Yep.
I expect this witness will testify next that Jimmie Tanks said she would look into gasoline when the time is right. This shows how the previous statement directly goes towards her decision to use gasoline.
Response? Defense?
Your Honor, if the prosecution would like to show that this statement goes directly to Jimmie Tanks using gasoline, then that means they're using it for subsequent action. And if right after Alex Leonard told Jimmie Tanks to go around and pour gasoline, Jimmie Tanks busted out of jail, got a canister of gasoline, and committed arson, then that's going to be subsequent action. But this conversation happened more than a year before Bertie Darrow's house was burned down. And there's no substantial proof that these statements caused Jimmie Tanks to take any subsequent action in using gasoline.
Your Honor, if I may.
Yeah, go for it.
Yes, Your Honor. A subsequent action doesn't need to be immediately after the action. And Your Honor, we're using this to show Jimmie Tanks formed a plan after hearing this statement. It doesn't matter to us that the statement is true or not. What matters to us is Jimmie Tanks heard it, believed it, and used it in their plan.
Last word, your objection, defense.
Your Honor, the prosecution just stated that it doesn't matter if Jimmie Tanks believes it, and if Jimmie Tanks believes it and uses it, that it's true, then that means that it goes to effect on the listener. But because Jimmie Tanks, they say, believed it and formed a plan, then it's being used for the truth of the matter asserted, linking Jimmie Tanks to the crime, and therefore under Rule 801, that's hearsay.
Okay. Appreciate the arguments. I do think that it's not being offered for the truth in this case, so we will admit the statement with a limiting instruction that it's not to be taken for its truth, but for the effect that it had on the listener. And if you want to probe into that effect on cross-examination, you may.
Yes, Your Honor. Ms. Huxley, did the defendant decide to use gasoline as his fuel for the fire?
Well, actually, I think so. That's why we're in court today, right?
Did you say anything?
Yeah, Tank said she would look into gasoline when time's right.
So were there any other interactions between the defendant and the arsonist?
Actually, yeah. There was a fire on May 5th. I didn't think too much of it, all right, except it happened when Tanks was in the room. After the fire was controlled, well, Tanks laughed and whispered to Leonard, not too bad for a trial run.
For the remaining time of the defendant's sentence, can you remember anything else about the defendant's fire?
The defendant's fire, well,
The last day I can remember is May 13th. It was this group therapy session, and Tanks drew a little picture. After she left, I just took a closer look.
Would you recognize it if I showed it to you today?
Yeah.
Your Honor, stating for the record, the prosecution is now screen sharing Exhibit 10. Miss Huxley, does this look fair and accurate?
Let me see. Yep.
Your Honor, at this time, prosecution moves to enter Exhibit 10 into evidence.
Any objections?
No objections from the defense, Your Honor.
All right, 10's in.
Miss Huxley, looking at this, what is this picture?
It's a drawing of a burning house.
I want to direct your attention to the upper left corner of that drawing. Do you know what it is?
Thank you. I see dates. That's July 1st and February 26th.
So we got a drawing of a burning house with the dates July 1st and February 26th. Do you know what those dates mean?
No. I don't know personally, but that date, February 26th, that points to a figure in jail.
Thank you, Miss Huxley. Nothing further, Your Honor.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good morning, Miss Huxley.
Hello.
Let's see if in the lyrics of your life, Jimmie Tanks ever gave you a reason to say, as Michael Jackson would say, she was the one who committed this crime. You used to be a high school security guard at Miss Tanks' school, right?
I did.
And just like courtrooms, schools have rules, don't they?
They do, yeah, and unfortunately I broke one.
Right, that no drug usage rule, you broke it because you were addicted to marijuana.
At the time, yes, but ma'am, I am clean, and it's because of Jimmie Tanks.
That's right, because of Jimmie Tanks, on one of your smoke breaks, she caught you smoking, right?
Yeah.
And you desperately wanted her to mind her own business, didn't you?
At the time, yeah. At the time, I thought Jimmie Tanks was a little narc that didn't need to butt into other people's business.
You were fired on the spot because that narc, Jimmie Tanks, couldn't keep a secret, right?
Exactly, ma'am, but now I'm so much happier. Look at me. I'm clean, I'm in a nice house. Life is great.
But at the time, you were filled with anger about this, weren't you?
Correct, ma'am, at the time.
Now, it's no secret you claimed a moment ago that Miss Tanks said some choice words while in jail. Let's take a moment and consider if there's any proof that Miss Tanks ever said these things, or if they might have been forged. You claim that she said, "One day I'll show Mr. Darrow what true fire looks like, and I'll do whatever it takes to make sure Bertie Darrow suffers." Right?
Yes. Mm-hmm.
And after you supposedly heard these things, you must have documented Tank's threats in a notebook, right?
No, of course not. Didn't think of it.
Miss Huxley, you heard these statements in 2021, right?
Yes.
And if you look at the top of your computer screen, what's the date today?
It is Sunday, March 16th, 7:34 a.m.
That's more than 3 years after you heard these statements, isn't it, Miss Huxley?
What year is it? 2025, yeah.
But you never wrote them down, and you're just reciting them verbatim.
No, I didn't write it down. It stuck with me, you know?
But surely you reported these threats to your supervisor, right?
No, not this threat.
Now, Miss Huxley, jails have security cameras everywhere, don't they?
They do, I suppose so.
But ma'am, you didn't show us any security footage of Miss Tanks ever making these threats, right?
Objection. Lack of personal knowledge.
Explain.
Yes, Your Honor. While we previously heard on direct examination that Miss Huxley's a security guard, we haven't heard anything about her ranking within the prison and if she even has access to the security camera footage. And since that foundation hasn't been laid on the record yet, we don't know if Miss Huxley has the knowledge about this footage and can even testify about it.
Before the response defense, what's the question that's exactly being objected to?
The question was, did you show us any security footage?
Okay, understood. Response.
Your Honor, this is cross-examination. If Miss Huxley doesn't have access to them, she doesn't know where they are, she doesn't show them, she can just say so.
Your Honor, if I may.
Yeah, last word.
Your Honor, the question opposing counsel asked is still calling for Miss Huxley to testify about something that might be outside her realm of knowledge. It could make her look less knowledgeable on these matters, and so the question must not be allowed in.
I think that's the intent. I think she can talk about if she has that or not. So overruled.
Yes, Your Honor.
Your Honor, may I proceed? Miss Huxley, you didn't show us a single piece of security footage of Miss Tanks ever making these claims, right?
Well, no, ma'am, I can't.
Now, let's figure out if you would forge the truth to make sure Jimmie Tanks suffers. There's a possibility that Miss Tanks can get sent to jail if she's convicted today, right?
Objection, Your Honor. Violation of the bifurcation rule. May I explain?
You may.
Your Honor, under the case law, we were provided State v. Clinton from 1998. All Tilly criminal trials are bifurcated with a guilt phase and a penalty phase. It is improper for an attorney to comment on sentencing or discuss potential penalties during the guilt phase of the trial. Right now, Ms. Ma's question is discussing if Ms. Tanks is found guilty today, she might be sent back to jail. She's talking about potential penalties, which is not allowed here in Tilly.
Response?
Your Honor, may I respond?
Yeah.
Yes. Your Honor, this question doesn't go to prove that this is a legally binding consequence that Ms. Tanks might face. Rather, this question goes to prove what the witness personally believes, and that goes to credibility. Your Honor, we're all good with a limiting instruction to make sure that the members of the jury understand that this is just a belief rather than an actual fact.
Response to that in the offer of the limiting instruction.
Yes, Your Honor, we believe this limiting instruction won't cover it since Ms. Ma right now is going into the penalty phases. She's talking about if Jimmie Tanks here today in court is found guilty, she might be sent back to jail, and then what happens after that. She's going directly into some things that happen after today's trial, and under the bifurcation rule, that's still not allowed.
I tend to agree. I'm going to sustain that objection to any mention of the word jail or jail time. You're free to dive into consequences that this witness believes may happen, but specifically to the use of the word jail or any sentencing time there, I'll sustain that objection.
Yes, Your Honor. Motion to strike?
Yes.
Now, Ms. Huxley, Willow County Jail is a jail where you have loads of connections at, right?
Yeah, I work there.
And if Miss Tanks ended up at Willow County Jail, you could use these connections.
Your Honor, I re-raise my objection.
Response? Defense?
Your Honor, I'm just saying hypothetically if Jimmie Tanks were to end up in jail, and Your Honor, we're not mentioning anything about any possible sentences, any possible punishments. We're just mentioning what Ms. Huxley's belief of if Jimmie Tanks were to go to jail and what would happen.
Can you give me an offer of proof? Where's this going?
Your Honor, we're just going to ask if Ms. Huxley could make Jimmie Tanks' life miserable in jail. That's all. We're not mentioning any statement, any sentences or anything.
Understood. Response?
Yes, Your Honor. As you previously ruled, any mentions of Jimmie Tanks being sent back to jail should not be allowed because it still violates the bifurcation rule. Because Ms. Ma here is specifically discussing that if Jimmie Tanks is found guilty today and if she's sent back to jail, then Ms. Huxley might potentially can have the connections to make her life miserable. But that still falls under the second half of the bifurcated phase.
I think as phrased, we get around the bifurcation issue. So I'm going to overrule the objection on the bifurcation grounds. Is there anything else?
No, Your Honor.
Okay. Then the objection's overruled. You may proceed.
Yes, Your Honor.
Now, Miss Huxley, I'm going to ask my question one more time. If Miss Tanks ended up at Willow County Jail, you could use your connections at Willow County Jail to make her life miserable.
Yeah, ma'am, I could.
And you could make that narc Jimmie Tanks' life miserable, couldn't you?
Oh, I wouldn't.
But you could.
In theory, yeah.
Now, you're actively helping today's prosecutors, aren't you?
Yeah.
To be clear, you weren't told to be here by the judge.
No, that would be weird.
And Miss Law didn't force you to take the stand, right?
No, she's my attorney.
That's right. She's your attorney, and you volunteered to testify against the woman you think deserves to be put in her place.
Oh, no, ma'am, that's not why I'm testifying. I'm testifying to get my statement out there. What I heard, and if it helps the prosecution, then be it.
You're, Miss Huxley, I'm just asking for a yes or no to my question. You volunteered to testify today, right?
My apologies, ma'am, yes.
Nothing further, Your Honor.
Any redirect?
Yes, Your Honor. Miss Huxley, I remember Miss Ma mentioned about your previous drug use. Why are you clean? Right here today in court.
Ma'am, I'm clean today because I was turned in by Jimmie Tanks, but that is the best thing that could have ever happened because I've been clean for 4 years.
And Miss Ma also asked you about whether or not you could make Jimmie Tanks' life miserable. My question for you is, would you?
No, I haven't in the past, and I wouldn't start now.
Thank you, Miss Huxley. Nothing further, Your Honor.
Any recross?
No recross, Your Honor. Miss Huxley can get back to her singing.
All right. Thank you, Miss Huxley. State, you guys got anything else?
No, Your Honor. At this time, we rest.
All right. Having rested, defense, or do you guys wish to put on a case?
Yes, the defense wishes to call Mr. Jordan Parks to the stand.
All right.
Good morning, everybody. Can you guys see me all right?
I don't think we can see you right now, Mr. Parks.
Oh my goodness. Oh, so I apologize. Maybe this button will do it. Can you guys see me all right now?
Yes, we can.
Oh, perfect. Sorry, I'm not very good with these. I think those youngsters, they call it the Zoom call. So I appreciate you all letting me take my time to figure it out.
Mr. Parks, thank you for wrestling with technical difficulties to be here today. First off, could you please introduce yourself to the members of the jury?
Sure thing. The name's Jordan Parks. I'm just a regular guy running a hardware store and nothing fancy.
Where are you from?
Oh, I'm from Mountain Brooks, back down south in Alabama, born and raised. It got a little too crowded and expensive out there, so I packed up and moved somewhere quieter.
What do you do for a living?
I run a hardware store called Nuts and Bolts. We actually have a brand of boats we sell here, and I named it after Mrs. Dolly Parton's song, Working 9 to 5.
Now, do you know why you're in court today?
Oh, yes. I helped out a woman named Jimmie Tanks, and another one, I believe it was Bertie Darrow, and both of them went to my store. Turns out Darrow's house burned down, so I reckon I'm here to tell y'all what I know about that.
Tell us a bit more about Miss Tanks. When did you first help her?
Oh, it was around, I think it was on June 2nd, 2024, when Miss Tanks came in looking for equipment to go sleep in the woods. That's not my cup of tea, but who am I to judge?
Why do you say she was going camping?
Oh, she told me she needed some rope, cloth, some gasoline, and then also this American flag.
Your Honor, speculation.
Explain.
Yes, Your Honor. This witness just testified that since Jimmie Tanks bought some cloth, rope, gasoline, and an American flag, he automatically assumes Jimmie Tanks is going camping. Your Honor, there's a lot of reasons why Miss Tanks could have bought some gasoline. For example, setting Bertie Darrow's house on fire. Miss Tanks never directly told this witness he'd be using gasoline for camping, so right now Mr. Parks is speculating.
Response.
Your Honor, the question that I specifically asked was, why do you say she was going camping? Now, I'm just asking what Mr. Parks thinks Jimmie Tanks is doing, and I'm not asking of any fact of what Jimmie Tanks is doing.
Last word.
Your Honor, since it is the prosecution's case theory that Miss Tanks bought gasoline to use it to set Bertie Darrow's house on fire, having this witness just testify that because she bought gasoline, she was on a camping trip for absolutely making this wild guess out of nowhere, that's still speculation.
I'm going to overrule the objection.
Yes, Your Honor.
Your Honor, may I proceed? Now, Mr. Parks, let's see if Miss Darrow had the fuel to forge a fire. When was the first time you saw Miss Darrow?
Oh, it was on July 25th, 2024. The day I actually got back, Bertie Darrow came in looking for painting supplies.
What type of painting supplies?
It was paint and then paint thinner. A lot of paint thinner.
Now, why do you say it was a lot of paint thinner?
They bought more paint thinner than paint, which is odd. You see, thinner is flammable, so we keep it locked up, separate from everything else in the store.
Did this concern you?
It did, yeah, because it was unusual to see an individual purchase a large amount of paint thinner. Even folks who've worked on painting large houses don't buy this much thinner.
Was there anything else that stood out to you about Miss Darrow's visit?
Well, you see, when it came time to check out, Darrow was short on funds. $1.75, if I remember right. I covered it. It wasn't much. It just felt like the right thing to do. I mean, they had this really rusty-looking car as well.
Did you have any other interactions with Jimmie Tanks or Bertie Darrow?
Oh, I did. Jimmie Tanks came in on the 1st of July, very late at night.
What happened once Miss Tanks showed up?
You see, Jamie ran in like my mom, God bless her soul, when she hears about a great deal, out of breath and complaining.
What did Miss Tanks need?
They wanted some gasoline, but we ran out, so I gave Jimmy some directions to another hardware store as I finished up my inventory.
Did Miss Tanks purchase anything else?
Oh, yes, they bought a pack of gum and then they ran off.
Mr. Parks, does Nuts and Bolts record the purchases of their customers?
Yes, ma'am, we keep receipts.
And would you recognize the receipts from those times when you talked to Jimmie Tanks and Bertie Darrow if I showed them to you right now?
Sure would, ma'am.
Your Honor, let the record reflect that the defense will be screen sharing what's been pre-marked as Exhibit 8B. Do you recognize this as a fair and accurate copy of the receipt from your interaction with Bertie Darrow?
Yes, ma'am. These match what I remember from their visits.
Did Miss Darrow buy more paint thinner than paint?
Yes. You see, Bertie bought 2 gallons of paint thinner for just half a gallon of paint. That's like bringing a gallon of ketchup for a single French fry.
And now, comparing these two customers, what differed from when you talked to them?
Oh, well,
Your
you
Honor,
see.
just procedural. We ask that they enter this exhibit into evidence before further discussing.
Yeah, response defense.
No, Your Honor, my apologies. We move to enter this exhibit into evidence.
Any objections to AB?
Yes, Your Honor, as to hearsay.
Okay. Response to hearsay defense.
You're under 8036. This falls under the record of a regularly conducted activity, and we're welcome to walk through all prongs of 8036.
No, that's okay. I understand. Response.
Yes, Your Honor. Specifically under 8036D, we don't believe this witness is a proper custodian. While he does work at this hardware store, that doesn't mean he creates these receipts or he should be able to testify about the contents.
State, has he not already testified to the contents of these prior to the admission of the document?
Yes, Your Honor.
Okay. With that, then I'm going to overrule the objection. 8B is in.
Yes, Your Honor.
Now, Mr. Parks, I want to back up a little bit. Did Miss Darrow buy more paint thinner than paint?
Yes, like I was just saying, they bought 2 gallons of paint thinner for just a half gallon of paint.
Now, comparing these two customers, what differed from when you talked to them?
Oh, well, I mean, they're both just some customers at my humble little store. Jimmie seemed like an outdoorsy gal, though, while Bertie Darrow, Lord, with that paint thinner, seemed like she might need to do some returns. I'd be happy to take them for her.
Thank you, Mr. Parks. Nothing further, Your Honor.
Thank you, ma'am.
Cross?
Yes, Your Honor. Good morning, Mr. Parks.
Good morning. How are you today, ma'am?
I'm doing well, thank you. How about you?
Oh, I'm doing great. Thank you for asking.
Well, I'm just going to ask a few questions, and then you can go right back to your hardware shop, all right?
All right, sounds perfect, ma'am.
So I want to begin with if the defendant was able to get the fuel for his fire from your hardware store. Now, as a hardworking employee, on July 1st, you stayed late at the shop before closing.
Yes, ma'am. And around 10:30, Jimmie Tanks came in, way past my closing time.
Exactly. The defendant ran in way past your closing time, and she was muttering things.
Sure, ma'am. They was out of breath and muttering things like, "There's no time. I need to hurry."
Exactly. And what the defendant was running out of time, what he really needed at that moment was gasoline, right?
Oh, yes, ma'am. You've got that correct.
But you told her you didn't have it anymore.
Unfortunately not. So I had to call up the store in Little Hamlet and gave her directions to go there.
Well, Mr. Parks, before you gave her directions, she panicked, didn't she?
Oh, yes, ma'am. Poor thing seemed really distressed, and they began to beg me to go check again.
Exactly. So distressed, she begged you to check again, so you helped her.
Yes, ma'am. Unfortunately, I had to tell her that we were out for the day. I was sure of it, but that's when I referred to her to that other store in Little Hamlet.
Right, you called the owner of the hardware store in Little Hamlet and gave the defendant directions on the map.
Yes, ma'am, that is precisely so.
She thanked you and rushed out at around 10:40 p.m.
Yes, ma'am, that's correct.
But even though the defendant was in such a rush, you didn't see her car leave immediately afterwards.
No, ma'am, but I did see a car resembling theirs driving down the single road outside my store later on.
Well, I want to bring you back to my question. You didn't see the defendant's car leave immediately afterwards after she rushed out the store.
No, ma'am, I'm sorry. Did that not answer the question perfectly? I'll be sure to listen more closely next time. Sorry, it's this hearing aid, you know. With the old age, you'll come to understand one day.
No problem, Mr. Parks. So is that a yes? You didn't see the defendant's car immediately leave afterward?
Yes, ma'am.
And since there's only one road, there's no way you could have missed it.
Oh, yes, ma'am, that is correct.
It was only several minutes later that you saw a car drive down that single road in the direction of Willow.
Yes, and that was the car that looked like Jimmie Tanks.
Right, the car seemed a lot like the defendant's. The headlights seemed distinctive.
Correct, and it had the shape that looked similar, but I couldn't tell. It was real dark outside.
Well, so the car you thought was the defendant's drove in the direction of Bertie Darrow's home that night, and not Little Hamlet?
Yes, that is correct.
Well, I want to talk about what the defendant might have been doing during those minutes in between before you saw her car rush towards Bertie Darrow's home. After the defendant ran out the door, you suddenly remembered there might be gasoline in the shed, right?
Yes, ma'am. We keep a spare case during power outages that we can use.
All right, you use the gasoline just in case of emergencies.
That is correct.
So it's safe to say it's always there.
Yes, it would be.
But when you went outside to check, you noticed the shed was unlocked?
Yeah, and not only that, ma'am, but the gasoline, it was gone. It just disappeared.
So bringing you back to my question, not only was that shed unlocked, the door was open.
Oh, yes, and the gasoline inside was gone.
The gasoline inside was gone? But you were certain you had locked that shed before.
Oh, yes, I was 100% certain I had padlocked it earlier that night. Now, don't let this gray hair fool you. I'm still as sharp as a lumberjack's axe.
So you were absolutely certain you had locked that shed.
Oh,
the only thing that was missing was gasoline.
Yes, ma'am, that is correct.
Gasoline. And that's the one thing Jimmie Tanks needed from your store, right?
Oh, no, they also needed this little pack of gum that they bought before they left.
Well, besides the pack of gum, gasoline was all the defendant needed.
That is correct, ma'am.
And thank you, Mr. Parks. We have nothing further, Your Honor.
Thank you. Have a great day now, ma'am.
You too.
Any redirect?
No redirect, Your Honor. Can Mr. Parks get back to his job?
Yes, thank you, Mr. Parks.
Thank you, Mr. Benjamin. I'll see y'all later.
Defense, you guys got anything else?
Yes, Your Honor, one more witness. We're going to be calling Mackenzie Reynolds to the stand.
All right. As soon as we get there we go. You may proceed when you're ready.
Excellent. Hello.
Good morning.
Can you go ahead and tell the jury your first and last name?
Of course. My name is Mackenzie Reynolds.
What do you do for a living, Miss Reynolds?
I'm an insurance investigator down at the Tilly Insurance Group.
What's your educational background?
I have two areas of expertise. One is actually in fire investigation, and the second is in structural failure investigations. I also have a Master of Science in Fire and Safety Engineering.
All right, and what type of investigation and fires do you have experience in?
I want to say for about 20 years, I investigated fires and arson-related crimes on the police force. My daughter, she calls me Sherlock Holmes, just with a fewer mysteries and more fire extinguishers.
Let's take a moment and investigate your involvement in this case. Ma'am, why are you in court today?
I'm here to talk about the potential financial needs of Miss Darrow. And I also investigated whether the fire at Miss Darrow's residence was deliberate or accidental.
All right, and those being the areas you focused on, what did you investigate?
Yes, so I reviewed the physical evidence, and then I actually conducted an inspection at Miss Darrow's house, as well as a gas chromatography mass spectrometry test.
How did you reach your conclusions on this case?
I used a method known as the double P method with sufficient facts and data.
Well, ma'am, let's see if the double P method might point to Miss Darrow forging a fire for funds. What do those two P's stand for?
Yes, they stand for property and second, patterns.
All right, and what does the first P stand for?
Right, so the first one's property. And I actually reviewed Miss Darrow's insurance policy and financial record just to verify her claims.
Stating for the record will now be screen sharing Exhibit 1, Miss Darrow's insurance policy, and 3, Miss Darrow's financial records. Ma'am, can you tell me what these are?
Yes. So, okay. So as far as I can see, yeah, that first one is Miss Darrow's insurance policy, and then the second one is Miss Darrow's financial records. And both documents don't seem to have changed.
Is it common practice for companies to maintain records of their clients?
Yes. So to my knowledge, this is common practice.
Excellent. Now, Your Honor, we're going to move to enter Exhibit 1 and 3 into evidence.
Any objections?
No objections, Your Honor.
All right, 1 and 3 are in.
Your Honor, can we go ahead and display them now for the members of the jury?
Absolutely, yep.
Now, ma'am, can you tell us why these exhibits on screen were important to you?
Well, as my daughter Jenny, she always likes to say, it's the cherry on top to their sundae, but really, it helped me conclude that Miss Darrow was in debt, and she owed $225,000 to that bank.
And did you find anything else concerning the funds?
Yeah, so if we're looking at those documents, I also learned that Miss Darrow would receive $900,000, allowing me to conclude that she did need the funds.
Let's talk about the second piece. What did the patterns mean?
So when I went to go take a look at that house, I observed and tested something called burn patterns. And actually, this is really interesting to me, but these burn patterns refer to distinctive marks or shapes left on materials like wood or metal after they've been exposed to heat.
Did you test those materials?
I did. I tested them just to determine if the fire was intentionally set. Those burn patterns were largely concentrated on the walls and also the front porch, indicating that use of some ignitable liquid.
And did you identify that liquid?
Yes, so through that GCMS test, I confirmed it was paint thinner.
And since we're not all experts like you, ma'am, could you walk us through how you tested for paint thinner?
Yes, I ran something, like I've said, known as this mass spectrometry test.
What's a mass spectrometry test?
Yeah, it's a good question. So basically what that MS test does is it separates and then identifies the samples or the substances in the samples based on what I gathered at the house. So actually, I brought a little demo. I borrowed it from my daughter's room, her little dollhouse. Don't worry, everything's going to be put back after. But as you can see in this demo, Bertie Darrow had mentioned that they were repainting the house, right? So I took samples from the substances on the front porch and then the outer and then inner walls right here.
How does this test work?
So the way this test works is that it detects exact substances found in the beakers I collected. And ultimately, I found large quantities of paint thinner instead of gasoline.
Can you go ahead and show us how that worked?
Yeah, of course. So what I'm going to do actually is I'm going to take some paint with my paintbrush. And what I'm going to do is I'm going to paint the interior of your house. It's a little dark in here, but you'll see where I'm going in a second. So I'm going to paint the inside of the house. You can't really see anything right now.
How would you find the large quantities of paint thinner?
Okay, so here's the fun part. So what I'm going to do is I'm going to take this light and I'm going to shine it on the interior of the house just like so. And as you can see, the inside of the house.
Your Honor, this meeting the jury, may I explain?
Yeah, go for it.
Your Honor, GCMS testing is an intricate scientific method that involves taking the sample and actually testing it, comparing it to what we already have. Your Honor, it is not as easy as shining a light. And because the witness here is showing such a simple and direct method, it is going to mislead the jury into thinking GCMS testing is easily as obvious or as reliable as the witness is portraying it, when in fact, there could be hundreds of factors factoring into the testing to begin with.
Your Honor, may I be heard?
You may.
Your Honor, if we look back at Rule 403, evidence has to be substantially more prejudicial than probative, or in this case, more misleading than probative. The probative value here is to break down, as Mr. Schuss just said, an integral scientific testing. We want to basically demonstrate to the members of the jury how simple Miss Reynolds' results came in. We're not merely saying that this is exactly 100% how this test worked. It's just to show her results of those tests. Your Honor, if you would like, you can dive into the reliability of this specific demonstrative on cross-examination, but we don't believe this has met that high 403 bar.
Response to that state?
But Your Honor, this has indeed met the high bar for misleading, because here the witness is demonstrating a very simple and frankly a method that is unlikely going to ever have any nuances to it. This is going to lead the jury into thinking that the GCMS testing she conducted is easily as obvious and simple, but in fact it is not, and there could be factors that make her result less reliable. Because this is making her result seem far more obvious, it is going to be far more misleading than probative.
Okay. I appreciate the arguments from both sides. I'm going to give our jury a little bit of weight here and believe that they can see some of these differences. So I'm going to overrule the objection, but you are free to either further object about the credibility of this test or to probe into that on cross-examination.
Yes, Your Honor.
Yes, Your Honor. Ma'am, can you go ahead and show us that light again? How did you find the large quantities of paint thinner?
Okay, so I'm gonna zoom in here. And as you can see, that part where I painted starts to glow. This flashlight that I'm using right here actually represents the mass spectrometry detector that identifies whether the substance was gasoline or paint thinner.
What would happen if there was gasoline inside the house?
So if there's gasoline inside the house, this entire house or the walls that I just painted would be entirely dark.
And was gasoline ever found in Miss Darrow's house?
No, so to my knowledge, gasoline was not found.
So what's your conclusion on this case?
Simply put, alongside the fact that Miss Darrow was in debt, there are alternative possibilities for the cause of the fire other than the accelerant identified by the state's expert.
Thank you, Miss Reynolds. At this time, Your Honor, no further questions.
Cross?
Yes, Your Honor. Good morning, ma'am. I'll ask you a few questions and I'll let you get back to your daughter. All right?
Yeah, of course.
Ms. Reynolds, I want to begin by talking about if your conclusions agree with the arguments your attorneys are making. Now, you conducted a thorough investigation in this case, right?
I did.
That means you looked at all the evidence you had available to you?
Right.
And you are an insurance investigator, aren't you?
I am.
Part of your job is to check for possible insurance fraud, isn't it?
Yes, it is.
And based on all this evidence you looked at, you cannot conclude that any insurance fraud happened in today's case, can you?
I can't. So that term insurance fraud is not something that I can talk about during this time, but I can conclude that Ms. Darrow was heavily in debt. But that is a yes to your question.
But you cannot even acknowledge that Miss Darrow had a motive to forge the file. Can you?
I can't. Just based off of my conversation with Miss Darrow, I knew that she was gambling and she did owe a huge amount of money to the bank.
But owing money, ma'am, for the members of the jury, owing money doesn't mean you're more likely to commit fraud, does it?
Right. No, obviously we can't tell that. But again, all I can tell is that she was in debt. Yes.
Let's talk about something you can actually tell. Now, you testified that paint thinner is a more likely cause, right?
Based off of my GCMS test, yes.
But GCMS testing, it isn't as simple as shining a light on the wall, is it?
Of course not. So I just wanted to provide this demo just to simplify all the complexities of that GCMS test for members of the jury, but yes, it's much more nuanced than that.
Well, you have to compare the results of what you see to actual paint thinner, right?
I'm sorry, sir, you compare the results of the GCMS test to paint thinner? I guess I'm
right. Right, Ms. Reynolds, you have to compare what you find in the house to actual paint thinner to know if the two materials are indeed the same, right?
Yes, you're exactly correct. And that's the way a mass spectrometry test occurs. So essentially what I did is I took the samples found on the outer inner walls and also the front porch, so the area and linear patterns, and I put into this mass spectrometry test. And basically what it does is it separates those gas compounds and it looks at those specific substances that detect paint thinner. But that's a yes to your question.
Ms. Reynolds, you were able to explain to us how the test worked, but you cannot show us your result, can you?
I can't right now, yes.
You don't have a graph to show us?
Not right now, I don't.
You don't have any of your data with you?
Not right now, just my words, but yes.
And GCMS testing, it has its limits, right?
It does.
You can't tell when a material was put onto the wall, can you?
No, I can't. It just detects what substances were on there.
Now you can't conclude if the paint thinner was put there weeks ago?
I can't.
You can't conclude if it was put there a year ago?
I can't.
And Miss Darrow told you that she recently repainted her house, right?
Yes, keyword recently. So that just gives me a little bit of a time frame, but that's a yes to your question.
Ma'am, say I have a cup of water right here. Are you able to tell when the water was put into the cup?
No.
All you can tell is that there is water in the cup, right?
Yes, but in this case, yeah, Miss Darrow did give me some context. She said that she had recently repainted her house, and I actually came to the scene 7 hours after, so it was then that I took those samples. Yes, though.
You know, GCMS testing also doesn't tell you where the fire started, right?
It doesn't.
Ms. Reynolds, you found paint thinner inside the house, right?
I did.
So you walked around inside the house, but you didn't check outside, did you?
I checked the outside walls and the front porch, but nowhere else.
So you didn't walk around the house to check for other materials?
No.
And you cannot tell the jury where the fire started, can you?
I can't. I just know that not only was it most likely arson, but the ignitable substance used was most likely paint thinner in my case. But that's a yes to your question.
Mr. Reynolds, I have nothing further.
Any redirect?
Yes, Your Honor. Ma'am, Mr. Shu just asked you about your method and your evidence. Ma'am, I want to ask you about your conclusion on this case. Did you conclude that Miss Darrow wasn't dead?
I did. So I know you brought up some exhibits, but
Objection, Your Honor, out of the scope. May I explain?
You may.
Your Honor, I have a good faith belief that opposing counsel is bringing in this line of questioning to rebut my pocket about how Ms. Reynolds cannot conclude there was insurance fraud. However, Your Honor, this is outside of the scope because I was questioning our conclusion that she cannot make, not her conclusion about the death.
Your Honor, may I be heard?
You may.
Your Honor, Mr. Shu concedes to my point. He did ask about the debt. Your Honor, he opened the door on cross-examination. I'm simply entering through it now with Miss Reynolds and asking about that debt.
Yeah, this court has a pretty generous understanding of scope, so we're going to give some leeway here. Appreciate the objection, but overruled.
Yes, Your Honor.
Redirecting you back to my question, ma'am, what did you conclude about the funds?
So Miss Darrow was in debt. She owed $225,000 to the bank. And as a result, she did need the funds.
And in your professional opinion, does someone who's in debt, who has almost $1 million insurance policy, ever commit these type of crimes?
Well, I would say it's more likely, right? Everybody has an inclination, especially when they are desperate in some sense. But again, I can't make any conclusion specifically for one individual.
Your Honor, no further questions.
Any recross?
Yes, Your Honor. Ms. Reynolds, I want to talk about your criteria for making a conclusion. Now, you would only make a conclusion if something is to a reasonable degree of scientific certainty, right?
Yes, you're correct.
You cannot conclude that Ms. Darrow had any motive to forge the file, can you?
Right. I mean, everyone has some sort of inclination based on the given circumstances. But again, I can't conclude anything about a certain individual.
Your Honor, I have nothing further.
All right. Any reread it here?
Your Honor, we're going to put out the fire that is this direct and let Miss Reynolds step down.
All right. Thank you, Ms. Reynolds. You may step down.
Thank you.
Defense, we got anything further?
No, Your Honor, we rest our case in chief.
Okay. Is it customary to take a break in this jurisdiction before going into closings?
Your Honor, it's up to you. That has been our understanding in the past, but if we would like to wrap up on this Sunday morning, we can go straight into closings.
No, let's not break from tradition. Let's do a break then. It's 8:24 my time. Let's do 5 minutes. So 8:29, we'll be back in session. All right, both sides having rested. We're now going to move into closing arguments. Are both sides back and ready to go?
Yes, Your Honor, the state is back and ready to proceed.
Okay. Defense, just give me some sign of life out there.
This is the sign of life, Your Honor. We're ready to go.
Awesome. There we go. Okay. I'm going to turn off my camera. State, you have the floor.
Yes, Your Honor. His fury filled the fire. Members of the jury, if there is one moment I want you to keep in mind from today's trial, it is that the defendant, well, they knew when to commit the crime from years ago. Members of the jury, you saw a drawing by the defendant herself, a drawing that showed a 2-story house going up in flames. And on the top left corner, members of the jury, 2 dates. the date the defendant went to prison where her fury started brewing, and the day of the crime when she allowed her fury to boil over and to fuel the fire that destroyed the house of an innocent person. For that reason, members of the jury, we've brought the charge of attempted first-degree murder and first-degree arson against the defendant because she intentionally set the fire to Bertie Darrow's house with the intention of killing her. Members of the jury, Miss Darrow, she was fortunate. She got away with her life, but only with a long scar down her entire arm. That is what the defendant did to the person who sent her to prison. Members of the jury, we took on a burden when we stepped in the courtroom today because we've sworn to prove to you beyond a reasonable doubt that the defendant is guilty. And we've achieved this because we've told you how the defendant's fury grew and grew until the moment when she felt out the gasoline, the fuel that burned down a house. But when the defense got up here, they only made you promises. They promised you that you will hear about insurance fraud, that you can hear about how Miss Darrow was the one who forged the fire. But members of the jury, they simply couldn't live up to their promise. Now, you've heard from their own expert today. Their expert testified the possibility of Miss Darrow starting the fire, well, it's not even reasonable. It's not something she can even conclude. But members of the jury, the law is what it is. The defense, they don't have a burden. They don't have to fulfill their promises at all. Because even though they simply forged a story about an innocent woman needing funds, well, members of the jury, we are the ones who brought to you the evidence today. The evidence of the fury. You've heard about the defendant and how she was threatening Miss Darrow threat after threat in prison. And you've heard about the drawing that she made that no one in this courtroom can deny, with the 2 dates leading you to the result. Second of all, members of the jury, the fuel. Today you've heard about how the defendant acquired the fuel by stealing it from a convenience store. Now the defendant, she ran up to the store and she was desperately begging the owner for a tank of gasoline. And do you know what happened when she couldn't get it? She stole it from the shack behind the store. And today you heard from a seasoned firefighter, the only expert who was able to bring to you a graph, a result sheet that showed gasoline was identical to all the material found around the house where the fire started. And third of all, members of the jury, the fire. I want you to think to the cost of this trial. Defense, they told you about the funds, but I'm here to tell you about the human cost the defendant left. The defendant caused a long scar down the arm of her victim. And why? All for revenge. Members of the jury, Miss Darrow might have gotten the funds in the end, but the cost to her, well, she is scarred for life by one person, the defendant who let her fury fuel the fire inside her. For that reason, we ask you to find the defendant guilty. Thank you.
Thank you, State. Defense?
Your Honor, may I proceed?
You may.
All right, let me just get a timer up really quick. She forged a fire for funds. The prosecution keeps telling you that fury fueled the fire. But in reality, Bertie Darrow's need for funds fueled this fire. Members of the jury, consider this. Imagine going to see a highly anticipated movie, fueled by rumors of a brilliant lead actor. But when the lights dim and the curtains draw, you're left with a cast of supporting characters that merely talk about the lead without ever showing them on the screen. You see, members of the jury, the prosecution is fueled by the heaviest burden in America's legal system. They don't just have to fuel their case with evidence, witnesses, and witty words. They've got to prove beyond a reasonable doubt that Miss Tanks burned down Bertie Darrow's house. And if there's even a single possibility in your mind that Bertie Darrow, not Jimmie Tanks, burned down that house, then Miss Tanks isn't guilty. This is Jimmie Tanks. She's 23. She's a nursing major, and she's been listening to today's entire trial. She's been listening to the prosecution using her as a scapegoat for someone else's crime. You see, Jimmie Tanks didn't take the stand today, but that doesn't change the fact that she's innocent until proven guilty. She's got her constitutional right not to testify, the same right that everyone in this room, you and me, has today. But it doesn't matter, because today we've proven that Bertie Darrow burned down that house with the funds and the fire. First, she needed funds. Why did Bertie Darrow need funds? What did she have to gain? Bertie Darrow's finances are fueling her financial instability. The hardware store worker told you that Bertie Darrow couldn't even afford to pay for the paint thinner she bought from him. But she won't have to struggle anymore if she comes out of today's trial fueled by that grand sum of almost $1 million. You saw her debt summary today. She was $225,000 in debt. She had 225,000 reasons to cause that fire. And second, that fire that she forged. How do we know that? You heard from the insurance investigator who showed you that the house is similar to how Bertie Darrow's house was covered in paint thinner, not only on the walls, but also on the porch. The store worker even told you that Miss Darrow had purchased way more paint thinner than she would have needed to paint a property. She didn't want to paint her house. She wanted to soak it with fuel and then let it go up in flames. Let's talk about how the state's expert was fueled by the need to blame this crime on someone. Today, you heard the state's expert agree on cross-examination to only suspecting Miss Tanks. Folks, think back to the analogy that my co-counsel gave you. If I were to turn my back, it's reasonable to say that I might miss something you did. The state's expert only focused on Miss Tanks and failed to see if Miss Darrow could have or would have forged a fire for funds. Or take the jail guard, who was fueled by the need to say Jimmie Tanks was the one who committed this crime. She tried to act like a songbird, and members of the jury, frankly, it was a good act until cross-examination, when she got real defensive, saying she only wanted to tell you the truth. She talked a lot about a drawing, but you didn't see a single piece of security footage from a security guard. The prosecution says they don't have it, but they could have called Alex Leonard, the arsonist that Jimmie Tanks was talking to. But instead, they called the same person who was filled with anger when Jimmie Tanks got her fired, the same person who voluntarily testified today. Members of the jury, she talked a lot about dates, but the only date that matters is March 16th, 2024. The day you'll find Jimmie Tanks not guilty. Now, I want to keep talking about what the prosecution has taken their foot off the gas pedal. You've seen a lot about a drawing that we don't know who drew, but Miss Darrow painted her own picture with her actions. Now that I think about it, the state has talked a lot about Miss Darrow, but Miss Darrow isn't even here. Look around this Zoom call. I see Judge Benjamin. I see Miss Tanks. I see Miss Garcia, but I don't see Miss Darrow. Because the state chose not to call her, and instead they chose to use her trauma to win pity points. It's just so easy to paint a narrative when the canvas isn't here. In order for the prosecution to fulfill their burden, they not only need to prove that Jimmie Tanks caused this fire, but that Bertie Darrow sustained serious bodily injuries. But members of the jury, you only heard someone seeing that injury from afar, and for all we know, it could have been painted. It could have been forged. And you didn't see a single piece of evidence proving that Miss Darrow sustained any serious bodily injuries. No medical exams, no records, no security footage, no evidence. So when you go into the deliberation room today, members of the jury, on this count, you're going to check no. Now, the prosecution keeps telling us we're unreasonable. Let's talk about who had the real feud today. The prosecution, that couldn't meet their burden. Because when they say that the fury fueled the fire, the truth is, funds fueled this fire. And Bertie Darrow forged this fire because she needed funds. Find Jimmie Tanks not guilty. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. 1 moment for me to put up my timer.
No worries.
May I proceed?
You may.
The defense does not even believe their own story, the one they are trying to forge to get a defendant out of the crime she committed. Members of the jury, I want you to think back to the 2 witnesses the defense was able to call today. And one of them, the expert in insurance policies, told you that it is not even a reasonable possibility for Ms. Darrow to have set fire to her own house. Now they talk about funds, members of the jury, but needing money doesn't make you a criminal. What makes you a criminal is you having your fury build up for years and the defendant making a drawing of the very crime she intended to commit. The evidence lay before you, members of the jury, because we have brought here witnesses and experts with no stake in this case who proved to you that the defendant must be guilty. Find her guilty. Thank you.
Thank you both. The judges are going to go ahead and finish up their ballots real quick and submit them. Judges, once you guys submit your ballot, will you just put into the chat for me that you've submitted it, just so I know we can go from there. Okay. I'm going to pass it over to our other judges here today. You guys have heard me talk. So we're just going to start randomly. Mr. Alfonso, if you want to begin with comments about things that you saw, things you liked, we'll go from there.
Absolutely. Hello, everyone, again. I'll keep it really brief. First, take a deep breath. It's over. Congratulations to both teams. It's an honor in itself making it here. Hannah and I were texting during the break. Hannah and I were in a final round of ourselves a few years ago, so I totally understand the emotions, what it takes to get here, and what you're currently thinking about. I think, one, you should be extraordinarily proud of yourselves, witnesses, attorneys. Our 2 character witnesses, absolutely hilarious. That's what I do at for UCLA. It's an absolute riot. You guys are absolutely exceptional. Then the attorneys, the masterclass of objections, even a concept that I'm still learning to this day. You know, you really showed an exemplary understanding of both of those. I think my one takeaway for both sides is a lesson that's taken me several years to learn, and it's the power of the pause. It builds suspense after a great point. It really shows that once you stop talking, I'm thinking, wait, why are they stopped talking? Oh, there it is. I think of both sides, whether through statements or even when you're delivering that joke and you know it's super funny and you're super excited to say it, just slowing down for a second and letting it pause and then hitting with it, oh, then everyone's like, okay, this is even more funny. So that's my one takeaway. But again, be super proud of yourselves, and best of luck in your future endeavors. Hopefully, if you continue on to mock trial and university, I think UCLA would be very honored to have any one of you. So congratulations.
Hannah, do you want to go next?
Sure. I echo everything that Nicole just said, and congratulations and a great job for an excellent final round from the both of you guys. For witnesses and attorneys, I'll give one broad piece that I really liked and one thing that I think you guys can take on to all the other tournaments and other rounds that you can do. On the witness side, I loved you guys on cross. I thought that you guys did an excellent job of maintaining credibility while also like undermining the cross examiner in some really smart ways, whether it was preempting or taking the spotlight away from what they were saying. I thought you guys were fantastic on cross. I think that on the flip side of something that you guys can improve on is thinking about not just going through the motions on like what words you're saying, but really like being trying to think about what the witness themselves would say in this situation, right? So it's a duel of both who is this person and how would they act in this certain scenario testifying in court. As for attorneys, I thought that my highlight this round were the objections. And it's not just because you guys are excellent at your rules of evidence, which you are. It's also because I thought that your demeanor in those objections also the best it ever was. And I think maybe it's because you weren't on a script or you weren't like thinking of it as a performance, but I really saw a lot of just yourselves. You were super reasonable. You're still persuasive, but you were also incredibly conversational and just like genuine in those moments. I want you to find somewhere where you can incorporate those in your performance, your scripted content as well. And that would be also my point of my recommendation for future rounds, in that I want to see more of yourselves, not just the performance that you're putting on. And one final thing I'll say about you guys is, regardless of what this round turns out to be, I hope that you have enjoyed it. Like you've really had fun in the experience, because as Cole knows as well, we did not end up winning that final round, but I still cherish those memories a lot because I got to spend time with my friends and my fellow teammates who I really love. And it's the moment of the rush before you're in the final round, the prep in between like cases in chief, like convening with your teammates, like how are we going to respond to this? They said this, what do I say now? Yeah, so I hope you're having fun, and I hope you keep having fun and you keep competing as well.
Judge Simon.
All right. I thought this was a phenomenal round. I obviously am familiar with this case at this point, but kind of seeing the little extra takes I thought was phenomenal. I agree with Judge Hannah. I thought the objection battles were phenomenal. Everything was great. I think if you take it, you take it sort of feedback would be, just for the purposes of Zoom, I think be mindful sort of your camera and your angles. I think you all thought about it, but there are moments where gestures were not caught on video, or I could see sort of shoulders moving, but I know you wanted to do more. Just be mindful of that. I know you all are mindful of it, but keep being mindful of it, because I think there are like moments where gesturings and things were not caught on camera. The other, I think, Zoom sort of specific final round thing I think the big difference to me between Zoom and in person is the ability to use the screen sharing and to build really powerful demonstrative, which I thought you all did, and the case in chief, but I didn't think you all took advantage of in the openings and closings as much, especially in the closings. I think you got to bring back your exhibits, bring back your evidence, bring back the verdict forms, right? I think that kind of thing. And you kind of do it in person a little bit, but I think there's even more power because of the animation and the transition ability that you can do in Zoom that you can't do in person. So I think definitely take advantage of that. And I think openings can do that as well, as far as, you know, building on your roadmap and your opening. So I think, right, I think frankly, I think you need to do that on the Zoom setting to kind of make sure you are at that top level, which you all are really close to or are at, in my opinion. That's all I have. Thank you. Thank you for allowing me to judge.
Thank you. But I'll be super quick about mine, guys. I've seen a lot of mock trial. I've seen pretty much every level of mock trial. I was not expecting to be as impressed as I am right now. I thought that was an exceptional round. I was expecting to give comments at a much different level, and then I saw the round. And I said, okay, they're ready for some different level of comments here. So I was blown away. I thought from start to finish, the procedural composure that both teams had going into this, especially for the nerves of a final round, was phenomenal. Two things to take away, and if you like it, great. If you don't, ignore me. Is for both sides and for attorneys in particular, when you get to such a high level and you're going up against such great teams, something that I think really starts to separate you from other teams is your ability to hone in and make a point out of small details. And I think for a judge who has never heard this case before, like myself, there were a couple of details I heard in the case, and I was like, I wonder if that's going to come back up. And sometimes it did, sometimes it didn't. But I think those real world kind of common sense details that we tend to lose when we kind of get so ingrained into the case really make the difference when both teams in these rounds are so clean, right? So polished. I think those are the things that kind of separate teams at this level. And I think that especially comes in during cross-examination where we can pick up on those details. And then one thing for my witnesses, I thought that your ability to fight and places to choose to fight on cross were terrific. I thought the decisions made were excellent. I think we can vary our strategies on cross of how we fight, how we go against these attorneys' questions. And so moving forward, looking into different ways that you can kind of navigate through cross that throws the attorney off without seeming like you're fighting. I just think there's a wider array of strategies that you guys can start using, and I think that'll take your game to the next level. That being said, I thought you guys were exceptional. Thank you for putting up with me and for allowing me to judge. This was incredible. Thank you.
I think we're ready for some results. Unsurprisingly, there was a split decision for the MVPs, for both attorney and for witness. I will announce the overall winners of these split decisions. Your overall witness MVP in this round, from the defense, Ms. Sailee Charlu. Split decision on attorney. Your overall attorney MVP in this round. From the defense, Ms. Christiana Garcia. One of the reasons I took a little longer going over these ballots was to verify the thing I'm about to say before I say it. This is the highest scoring round in the history of IMT elimination rounds. Not a single judge gave a single score below an 8 to anybody for anything. It was also a unanimous decision for one side. On a 4-0 decision, your winners and still champions from the defense, Team Gold. Congratulations to both teams, and for folks watching us in the future, we hope to see you at the next IMT tournament.